Constitution, due process, and the right to habeas corpus if individuals are detained.
And we absolutely protect those rights.
And I believe also that Congress has the privilege to be notified if someone is detained and has the ability to both intervene or interact with the executive, the president, on the particular unique circumstances of someone being detained as a person that may be involved in terrorist acts. I thank the gentleman and would argue the point that this is a challenge, but that this bill has a value of changing the law, of improving the law on the question of the Constitution, and I yield back my time with the support of this legislation.
Gentleman from Virginia.
Thank you, Mr. Speaker. I yield 1 minute to my friend and colleague, the gentleman from Illinois, a member of the Conference Committee, Mr. Schilling.
The gentleman from Illinois is recognized for 1 minute.
Thank you, Mr. Speaker. I rise today in support of the NDAA conference agreement. First, I want to thank Chairman McKeon and Ranking Member Smith for shepherding this bill through the committee and through the Armed Services Committee and really doing a great job for our brave men and women. This marks the 50th year of the NDAA passing, and it is truly an example of bipartisan cooperation for the good of our country. I appreciate the opportunity I've had serving on this important conference, and I believe that what we have put together is a great framework that is fiscally responsible and supportive of our troops and national security. Included in this bill were provisions that would help support our military organic base, including arsenals like the one in which I represent in Rock Island. I'm proud to represent this national treasure found within the Department of Defense. The Rock Island Arsenal and its 8,600 employees have worked hard for our country. One of the provisions that was included in the NDAA allows our Army industrial facilities to enter into public-private partnerships under Section 4544. This provision does away with the cap on these partnerships and ends the sunset. I urge strong support in this passing of this.
Expired. Gentleman from Washington.
Thank you, Mr. Speaker. I apologize. May I inquire again as to the time left?
The gentleman from Washington has 6 1/2 minutes. The gentleman from Virginia, 5 1/4.
Thank you, Mr. Speaker.
And the gentleman from New York, 4 minutes.
I'm pleased this time to yield 3 minutes to the gentleman from Georgia, Mr. Bishop.
The gentleman from Georgia is recognized for 3 minutes.
I thank the gentleman for yielding. Mr. Speaker, in a few minutes I will offer a motion to recommit that would strike a misguided provision in the conference report that would exempt TRICARE network providers from our labor protection laws. Section 715 of this conference report excludes the TRICARE network healthcare providers from being considered subcontractors for purposes of any law. Section 715 is nothing but an attempt to override pending litigation and long-standing civil rights law under Executive Order 11246 of '65, Section 503 of the Rehabilitation Act of 1973, and the Vietnam-era Veterans Readjustment Assistance Act of 1974. The civil rights protections contained in these laws have existed for decades, and they've served to protect millions of workers from race, sex, and other forms of illegal discrimination. Large federal contractors are simply required to have an affirmative action plan to assure that minority groups are not being discriminated against and that the Department of Labor reviews the records. The law currently exempts employers with fewer than 50 employees who do not meet minimum contract dollar requirements. The healthcare industry employs approximately 16 million workers in 2009. Hospitals and similar entities employ tens of thousands of minorities, women, veterans, and low-wage workers, groups that historically and currently depend on the basic assurances of fair treatment. The healthcare industry is the largest growing sector of employment in this country. Veterans would be especially hard hit under this change in the law. There are close to 900,000 unemployed veterans in America right now. Despite their unique experience and leadership skills, wounded warriors and veterans often struggle to find meaningful employment in the civilian sector. That's why Congress passed laws enforced by the Department of Labor to protect the brave men and women who have served our country. The Office of Federal Contract Compliance ensures that federal contractors and subcontractors do not discriminate against our veterans and instead take steps to recruit, to hire, to train, to promote qualified protected veterans. TRICARE providers, the very people that provide health care to our nation's veterans, are arguing that they should be exempt from adhering to the very regulations that were passed to protect our veterans. This action would gravely undermine our efforts to employ veterans. These large government health care contractors should not be exempted from civil rights responsibilities that apply to all other similarly situated contractors or subcontractors. Section 715 is a brazen attempt by large health care industries to overturn pending litigation and exempt themselves from civil rights scrutiny. Congress should vote against weakening these laws, and I urge my colleagues to join with me and support my motion to recommit the conference report. I yield back the balance of my time.
The gentleman yields back the balance of his time. For what purpose does the gentleman from Virginia rise?
Thank you, Mr. Speaker. I would like to yield a minute and a half to my friend and colleague, the gentleman from Missouri, the chairman of the Small Business Committee and member of the Conference Committee, Mr. Graves.
Gentleman from Missouri is recognized for 1.5 minutes.
Mr. Speaker, I rise in support of Conference Report H.R. 1540. Included in this bill is a long-term reauthorization of the Small Business Innovative Research Program. This program sets aside federal research and development dollars for small businesses that have cutting-edge ideas and promising research that the government needs. The SBIR program fosters innovation while giving a boost to our nation's best job creators. Today I'm pleased to say that the House and Senate have come together on a compromise that will give certainty to our small businesses and make important reforms to the program. I want to thank Chairman McKeon and Ranking Member Smith for including this bipartisan deal in the National Defense Authorization Act conference report, and I'd also like to thank the Ranking Member of the Small Business Committee, Ms. Velasquez, for her very important contributions to this debate, as well as the Chairman and Ranking Member of the Science Committee, Mr. Hall and Ms. Johnson, who have also been partners in this effort. And of course, Mr. Speaker, all of the staffs on the various committees that came to and worked very hard on this, they deserve a lot of credit for their hard work. So I'd encourage my colleagues to support the conference report and the thousands of small businesses and jobs that benefit from the SBIR program. And with that, I'd yield back the balance of my time.
Gentleman yields back. The chair would serve notice that the gentleman from Virginia has a remaining 3 3/4 minutes. The gentleman from Washington has 3.5 minutes. The gentleman from New York has 4 minutes. What purpose does the gentleman from New York rise?
Mr. Speaker, I'll reserve until it's time to close.
Gentleman reserves.
I'm also going to reserve until it's time to close.
Gentleman from Washington reserves. Gentleman from Virginia.
Mr. Speaker, I continue to reserve the balance of my time.
If I may ask, does that mean that you're ready to close?
Mr. Speaker, I would tell the gentleman yes.
Okay. I believe you're right.
The gentleman from New York is recognized to close. 4 minutes, sir.
Thank you, Mr. Speaker. I yield myself the balance of my time.
Gentleman is recognized for the balance of his time.
Thank you, Mr. Speaker. We are told, and this seems to be one of the principal issues in the debate today, that this bill with reference to the detention and security provisions merely codifies existing law. Some of us say no, it doesn't codify existing law. It codifies claims of power by the last 2 administrations that have not been confirmed by the courts, by some courts, but not by the Supreme Court. Rather terrifying claims of power, claims of the right to put Americans in jail indefinitely without a trial, even in the United States. Now, I could cite specifics here. Now, the text, for example, says very specifically that Congress affirms the authority of the President includes the authority for the armed forces of the United States to detain covered persons pending disposition under the law of war, and then expands the definition of covered persons to people not implicated or supporting or harboring people implicated in 9/11 for the first time. And then we have a provision that says nothing in this section is intended to limit or expand the authority of the President or the scope of the authorization for use of military force. Well, that directly contradicts what I just read, which is a very specific provision, and since the rules of statutory construction always say that the specific controls the general, this provision, frankly, and insofar as it contradicts the first, is meaningless. It provides no protection whatsoever. And the same is true of the Feinstein Amendment for similar reasons. Now, we have disagreement we heard on the floor today, but that reflects the disagreement in the country at large. We have many law enforcement people. Many legal scholars disagree on what this language means. The President's chief counterterrorism advisor, John Brennan, said that the bill mandates military custody for a certain class of terrorism suspects, and since it would apply to individuals inside the U.S., which we've heard denied on the floor, but the President's counterterrorism advisor thinks it does, it would be inconsistent with the fundamental principle that our military does not patrol our streets. And we have many generals, including the former Commandant of the Marine Corps, saying that this is a terrible expansion and change of existing law. Now, the fact that whether it simply codifies existing law or further restricts our liberties in unprecedented ways is unclear. That my friends here can say it only codifies existing law, and I can say, and all these other people, experts, legal experts, military people, counterterrorism experts can say it goes way beyond existing law, shows why it is dangerous to have this kind of provision affecting fundamental rights and civil liberties in a defense authorization bill, which is admirable in many other ways. The Armed Services Committee is not the proper place to consider questions of civil liberties and legal rights, and certainly not a conference report. All these questions should have been considered in hearings. The Judiciary Committee in both houses, frankly, should have held hearings. We should have called in the counterterrorism experts. We should have called in the legal scholars. We should have called in the statutory scholars and say, what does this provision mean? How should it be changed? Does this provision contradict that provision? And what does it really mean? And does it go beyond existing law? And if so, how can we change that? On legislation like this, there should be hearings and testimony and proper debate and consideration. Now, we can still fix this. If we defeat this bill now, we can then take these provisions out of the bill, pass the bill without this provision in a couple of days. We're going to be here. There's no reason we shouldn't do that. And then next year, which is only a couple of weeks away, give proper consideration to these detention provisions if people feel a felt need to pass them. We should not do such fundamental changes on the fly in a conference report with 1 hour debate, no proper committee consideration, no public hearings, and considerable disagreement among scholars and judges and counterterrorism experts and military experts as to what this language means and what it does. The true answer is that nobody on this floor can be 100% certain what this does, and when you're dealing with our fundamental liberties, that should say, don't pass it. So I urge my colleagues to defeat the bill. We can then take this out of the bill, take the bill up on the floor again in a couple of days, and that's the safe way to safeguard our liberties and to do what we have to do for our military security. Thank you. I yield back.
Time has expired. The gentleman from Washington is recognized to close.
Thank you, Mr. Speaker. I yield myself the balance of my time.
The gentleman is recognized for the balance of time.
Let me just say we had hearings on this last February and March. We had language in our bill which we passed in May. This issue has been thoroughly debated. Now, I've heard a couple of times that the Judiciary Committee has not heard this issue. This has been going on for 10 years under both Democratic and Republican control. I don't know why the Judiciary Committee has not chosen to have hearings on this issue, but that's hardly our fault. We have. We've had endless discussions on this. It has, in fact, been debated. And let me also say that I am very concerned about these very issues. On our committee, I have been one of the strongest voices of concern. I support closing Guantanamo. I know a lot of people don't. I think we should have all of those suspects here in the U.S., that we should try them. I also strongly believe that the criminal justice system has to be part of how we combat al-Qaeda. I have heard the argument, people say this is a war, not a criminal matter, why are we bothering with, things like Article III courts? I disagree with that, and have spoken out publicly and strongly, and in many cases, even when popular support has been on the other side of issues like closing Guantanamo. I care deeply about this issue, and from the very start, fought hard to protect precisely the things that Mr. Nadler is referencing. I fought hard in the conference committee to make sure that they were protected, and they were. Now, the argument is we don't know exactly what it means, so therefore we should do nothing. It is very true that law is unsettled. But that's, again, got nothing to do with this bill. There are court cases ongoing. There are habeas cases continuously happening as a result of Guantanamo, and it's being interpreted by courts and also by the executive branch. Let me make it also clear. The judiciary and the executive branch, they would always rather that we do nothing. They would always rather forget that we are supposed to be a co-equal branch of government, but we are. After 10 years and after countless hearings, the legislative branch should say something about this. And what we said very, very carefully to simply codify what the executive branch and the judiciary have said about the AUMF and to make absolutely clear, and this language is not ambiguous, that military custody in the U.S. does not apply to U.S. citizens and does not apply to lawful resident aliens. Again, the problems that people have, and I share some of them, are with existing law, not with this bill. Defeat this bill and it won't change a piece of that existing law that we've heard about that we should all be concerned about. But defeat this bill and it will make it very difficult for our troops to get the support they need. Now, I've been around this process long enough to know there ain't no guarantee of fixing anything. And if we defeat this bill, our troops will be left to wonder if they're going to get that pay raise, if those military support projects are going to get built, if our troops are going to get the support they need, and I don't know the answer to that question. So there is a ton of very, very good stuff in this bill that supports our troops, that addresses members' concerns on issues like sexual assault within the military and a whole host of others. We need to support this bill to support our troops. And the issues that folks are concerned about on detention, again, that is existing law. Whether this bill passes or not, those controversies will continue. This is an excellent piece of legislation, well-crafted, worked hard by a lot of folks. It deserves an overwhelming yes vote. I urge passage, and with that, I yield back the balance of my time.
The gentleman's time has expired. What the gentleman from Virginia is recognized to close.
Thank you, Mr. Speaker. I yield myself the balance of the time allowed.
The gentleman is recognized for the balance of his time.
Thank you. Mr. Speaker, I want to thank our conferees and the members of the Armed Services Committee once again, and I want to thank our staff directors, Bob Simmons and Paul Arcangeli. This conference report addresses a wide array of policy issues, from cooperation with nations like Israel and Georgia, operations in Afghanistan, our new partnership with Iraq, balancing strategic opportunities and risk with respect to China and Pakistan, to mitigating the threat from Iran and North Korea, enhancing missile defense, and maintaining this nation's nuclear deterrent. Passage ensures our troops get a 1.6% pay raise and the benefits their families rely upon. This bill also ensures that we continue to fulfill our nation's most sacred obligations to our brave men and women serving in the greatest all-volunteer force in history. The service by our men and women in uniform is priceless, especially during the last 10 years of combat operations. Besides thanking them for their service and sacrifice to this nation in ensuring they are afforded the best benefits and care for their service, there is little we can do to repay them for standing the watch and keeping America safe. This bill authorizes a modest 1.6% pay increase, but it never can express how truly grateful we are as a nation for the service and sacrifice of our all-volunteer force and their families. Additionally, some very important provisions were included to ensure our industrial base maintains a constant workload and a fully employed workforce. $14.9 billion was authorized for U.S. Navy shipbuilding, a total of 10 ships, which include 2 Virginia-class submarines. The bill also extends the multi-year funding authority for the 2nd and 3rd Ford-class aircraft carriers for 4 to 5 years of incremental funding authority. American ingenuity, creativity, and initiative are alive and well in our shipyards that build warships for the United States Navy. Shipbuilding is supported through business and industry spanning 50 states and designed and engineered by our greatest asset, the American people. The American aircraft carrier is the pinnacle of this industrial engineering ingenuity and genius, where mechanical, nuclear, aerospace, and electrical engineering converge with naval architecture to form a magnificent 100,000-ton, 1,092-foot long piece of American sovereignty that travels anywhere, anytime around the world. Additionally, the bill reinstates the requirement for annual delivery of the Navy's 30-year shipbuilding plan, solidifying the need for the Navy to communicate their plan as it relates to the strategic objectives of the United States, balanced against a very challenging budget environment. I'm pleased that this legislation came together to support our men and women in uniform. In times of austerity, they remain a priority as does the safety and security of this nation. Today, I stand in support of this legislation and encourage my colleagues to support its passage. I would like to reflect that all 26 Senate conferees signed this report, and 29 out of the 32 core House conferees signed as well. This is a solid product, thoroughly debated and deliberated considerably. I urge my colleagues to support and vote in favor of the conference report. And, Mr. Speaker, with that, I yield back the balance of my time.
The gentleman yields back the balance of his time. All time has expired. Pursuant to House Resolution 493, the previous question is ordered. Pursuant to Clause 1C of Rule 19, further consideration of the conference report is postponed. And pursuant to Clause 12A, Rule 1, the House will stand in recess subject to the call of the Chair.
And we expect when the House comes back that they will finish up work on the 2012 Defense Authorization